My talk today is about the presumption against extraterritorial criminal jurisdiction, and I'm going to talk specifically about prescriptive or legislative or adjudicative jurisdiction, not so much about executive jurisdiction. Although hearing from Cedric Ringard yesterday, we might not need to make that argument or extend the argument to enforcement jurisdiction very soon. So the fact that there is, or there seems to be, a presumption against extraterritorial criminal jurisdiction seems to be a fairly common assumption among international lawyers, at least, because it's normally required for any form of prescriptive jurisdiction or adjudicative jurisdiction that a state can point to a particular nexus with the offense or with the offender. So perhaps the principle of nationality, the principle of passive personality, the principle of protection, and even the principle of universality work as arguments against this general presumption. How there's a difficulty at the core of this presumption, which I think is captured by the reasoning of the majority in the Lotus case. So in the Lotus case, one of the most famous cases in international law, the majority of the Permanent Court of International Justice made the following reasoning, which I think it pays to quote in full. This is the only long quotation we'll have in the whole presentation. So the majority says, it does not follow that international law prohibits a state from exercising jurisdiction in its own territory in respect of any case which relates to acts which have taken place abroad, and in which it cannot rely on some permissive rule of international law. Such a view would only be tenable if international law contained a general prohibition to states to extend the application of the laws and the jurisdiction of the courts to persons, property, acts outside the territory. But this is certainly not the case. So the Permanent Court here says there is no presumption against extraterritorial jurisdiction, extraterritorial criminal jurisdiction. Rather, the argument or the rule is the opposite one. There is a presumption that this is permissible, that this is compatible with international law. Now, this reasoning has been rejected by a number of important scholars in the field. Francis Mann, in his classical work on jurisdiction, called it retrograde. Dame Rosalind Higgins suggested that the reasoning was outdated. Cedric Ringard suggested it's obsolete. Bruno Sima, in one of his decisions in the International Court of Justice, called it anachronistic. And Vaughan Lowe and Staker call it fallacious. So this is not a very popular reasoning. One of the first thing I want to do today is understand why the reasoning is wrong. What's wrong with the reasoning? And the way in which we can start to examine this question is to assess what kind of right, the right to exercise jurisdiction or to adjudicate in these kind of cases is. So jurisdiction is a legal right. We all seem to agree on this. Some argue that it is a claim right, to use Wesley Hochfeld's classical classification. So, for instance, Justice Finlay, in his dissent in the Lotus case, citing Lassa Oppenheim, suggests that jurisdiction correlates, these are my words, but capture exactly what Finlay said. Jurisdiction correlates with other states' duty to acquiesce in the defendant's punishment. So the right of a state to exercise jurisdiction means that some other state is under a duty to accept that decision. I don't think this captures well what we've read about in the reasoning of the majority of the court. And Marita Keuchi, which I think is here today, she has criticized this view. And she says, well, Lotus is not about claim right. In Lotus, the freedom to exercise jurisdiction only entails a Hochfeldian liberty, which is that states are in principle under no duty not to extend their jurisdiction extraterritorially. So all the court, or the majority of the court, suggested was that it was merely permissible. They didn't have a claim, right? They didn't have a right that other states respect their decisions, but they were not under no duty not to do what they wanted to do. This view is compatible with the general understanding, which I think is in all the relevant literature, that the laws of jurisdiction contain principles that regulate horizontal relationships between equal sovereigns. Now, here's an important bit. So if jurisdiction must be either permitted or prohibited, there's a liberty or there's no liberty, there's a duty not to exercise it, and there's no clear prohibition under international law, then it seems to follow that the following two propositions must be wrong. The first proposition is that everything that is not prohibited by international law is permitted, and the second one is that there is a presumption against extraterritorial criminal jurisdiction. Now, as you gathered from my initial remarks, I think it's true that there is a presumption of extraterritorial criminal jurisdiction. Most people accept this is correct nowadays. And I also think it's true that everything that is not prohibited by international law, I think in most legal systems that are sufficiently normatively defensible, in all these normative systems, everything that is not explicitly prohibited must be permitted. So my sense is that the problem is in the first proposition, that we must think about extraterritorial jurisdiction as being either permitted or prohibited, that is subject to a liberty right or a duty not to be exercised. So, as I said, perhaps jurisdiction is neither a claim that states have, that other states accept their verdicts, nor a liberty that states have, which means a lack of a duty not to exercise it. Perhaps I think jurisdiction can be better conceptualized as a normative power. Normative power, following Hochfeld again, are second-order rights that allow an authority to modify the liberties and claims of a subject. And this is fairly easy to see in the trial sort of scenario. So when a defendant enters a courtroom, if she or he is convicted, then her moral boundaries are going to be redefined. Her liberties are going to be changed by the decision of the court. So liberty to move freely, some of the other claim rights and liberties she has will be affected. And this is precisely the exercise of a normative power, not just a liberty, not just a claim right. Now, while liberties capture horizontal relationships between equals, powers establish vertical relations of authority. So jurisdiction and particularly extraterritorial criminal jurisdiction is not just about horizontal relationships between states, but rather it's about vertical relationships between states. So to illustrate, and following here Nico Krisch's recent Jurisdiction Unbound, states use their regulatory and judicial institutions very effectively to govern activities of companies abroad. And this establishes hierarchies, not only over those companies, but also over other states, whose ability to define their own policy is thereby curtailed. So extraterritorial jurisdiction and extraterritorial criminal jurisdiction in particular is not just about a liberty of states to do what they want, but it also entails a way of exercising authority on other countries' territory. And similarly, during the 19th century, extraterritorial criminal jurisdiction formally shaped vertical relations of authority between core states and the periphery. And this can be very easily seen in capitulation treaties, which were ways in which particularly Europe established its authority, or European countries established their authority on the territory of Turkey or the Ottoman Empire or China, and so on and so forth. And it was precisely a way of regulating conducts, commercial conducts, economic conducts, and also criminal conducts on the territory of these so-called semi-civilized countries. So I think that this view, considering jurisdiction a vertical relationship and not just a horizontal relationship, explains to a significant extent why legal systems normally have a presumption against anyone having a legal power. Powers, unlike liberties, must be explicitly conferred by the legal system. And we can see this very easily with powers of attorney, but also with the jurisdiction of domestic courts, which is often its scope and its basis. And it's usually conferred explicitly either by constitutional text or by legal text from Congresses or parliaments. So unlike liberties, we, in any legal system, or in most, or in any existing legal system, powers are explicitly conferred, and there's a presumption against individuals or agents having them. So if we conceptualize jurisdiction as a normative power rather than as liberty that establishes vertical relationships of authority between states, this allows us to understand two important things. First, which is the initial challenge I presented, where the court in Lotus got it wrong. The fact that it didn't see jurisdiction as a normative power made it impossible to understand that the presumption in favor of jurisdiction did not apply. At least the majority made that mistake. And secondly, why it makes analytical sense to talk about a presumption against extraterritorial criminal jurisdiction. Now, there's a second step, which entails what is the scope and weight, normative weight or normative force of this presumption, how strong this presumption is. Some people believe, and I use Joseph Story classical terms here, that jurisdiction of a state, territorial jurisdiction of a state is absolute and exclusive. This would mean, of course, that there's no possibility or no authority to exercise extraterritorial criminal jurisdiction. And this view was, I think, originally stated by Ulrich Huber in the 17th century, and also by Chief Justice Marshall from the US Supreme Court in the famous Schooner Exchange versus McFadden case. So this was a popular view. It is not a popular view anymore, and this is partly because of some of the reasons I think Matej is going to talk about later, which is that it is not sufficiently sensitive to the rights of individuals in other states, as well as not particular or not sufficiently sensitive to the rights of individuals in the territorial state. So we could think of millions of Germans under Nazi rule whose interest was that the German activities were not under the exclusive jurisdiction of the state, and we can similarly see the interest of individuals in Rwanda in 1994, or in Argentina in the 70s, or Chile in the 70s, and so on and so forth. So there are reasons which militate against extraterritorial or the jurisdiction, the territorial jurisdiction of a state being absolute, as a story suggested. So this means that if there is a presumption, the presumption is defeasible under certain circumstances, and those circumstances entail the interest of individuals inside the territory of the territorial state and outside it. So I'm going to present a number of contingent and non-contingent arguments to see how strong the presumption is. The first argument is, the first family of arguments are those that I call contingent, because they, of course, apply in some circumstances, but not in every circumstance of extraterritorial criminal jurisdiction. So the first argument is that the accused, the victim, and the evidence are normally in the state where the crime has been perpetrated. This is similar to the forum non-convenience clause in private international law, and it makes sense. But of course, as I said, it might be the case that all the evidence that the accused and the victims have moved to another country. I think Maximo Langer has a forthcoming paper precisely on how migration affected universal criminal jurisdiction. The second contingent argument is that extraterritorial criminal jurisdiction creates tensions between states, and the Lotus case is an example of that, but we can see stronger dissents, such as the problems that the US and China had with universal jurisdiction claims by Belgium and Spain in the late 90s, early 2000s. Of course, this doesn't mean that the objections were right, but it means that this kind of extraterritorial criminal jurisdiction will create tensions between states. The third argument was put forward by Judge Altamira in his dissent in Lotus, who suggested that the rights of defendants might be severely affected by extraterritorial persecutions because defendants will be subject to trials in languages they normally don't speak, by procedures they normally don't understand, according to rules and on behalf of communities they don't know necessarily well. Again, this might not be the case. The defendant might be a national of the state, or it might speak the language. So again, this is a contingent argument, but it can apply to this kind of extraterritorial forms of jurisdiction. I think a powerful argument against extraterritorial criminal jurisdiction is that it allows for neocolonial forms of domination by powerful states over weaker ones. And this is partly what I captured in the capitulation treaties frame a few minutes ago. And the fact that only a few powerful states are normally going to exercise this kind of extraterritorial criminal jurisdiction, and they're going to normally do it against weaker states. And they're going to normally use it as a way to impose upon them their authority to regulate certain criminal acts, to regulate certain forms of economic relationships, is, I think, one of the strongest arguments against accepting extraterritorial criminal jurisdiction on a regular basis. Of course, this is, again, a contingent argument. It might be the case that Argentina prosecutes Spanish former officials for crimes against humanity. It might be the case that there are relationships between extraterritorial criminal jurisdiction between countries in the global south, but the general cases, or in many cases, this is a very strong reason against it. Now, I think that there's also a non-contingent argument, which I think we need to look closer to, which is that extraterritorial criminal jurisdiction affects the right of self-government of the political community over which it is imposed. This argument has been made before, but I think it pays to unpack it a little bit. On the one hand, this means, or this acknowledges that penal policy is a central aspect of collective deliberation, which includes not only substantive crimes, such as in Argentina. Recently, we've had a big debate over decriminalization of abortion rights. And this and other debates on which conducts to criminalize, which conducts not to criminalize is a significant part of the political life of any political community, of any state. But this also includes criminal procedure and appropriate penalties, which are also decided by each political community. And this right to decide what are the basic moral rules that regulate the life, the shared life of our political community, is affected when we accept the authority of a foreign body or foreign state. And secondly, criminal trials involve a form of moral communication, and in the context of conviction, moral censure between a political community and the accused who is brought to account for her conduct. So again, I think that there's a relationship between the community, the political community that brings an individual to account and the offender, and that this relationship is very important for the business of criminal jurisdiction. And so when there is not such a relationship as when the act is perpetrated extraterritorially, then we have reasons not to accept the authority of that political community or the extraterritorial political community over the defendant. So, in sum, this means that extraterritorial criminal jurisdiction is objectionable to different degrees, depending on how many and which of these arguments apply in a given situation. However, it also means that such a presumption stands even in the case where none of the contingent reasons would militate against it. Now, my conclusions. I think that there are strong systemic and normative arguments in favor of a robust presumption against extraterritorial criminal jurisdiction. I think the strength of this presumption means that it is not only the case that the forum state has the burden of proof to show that extraterritorial jurisdiction is warranted, but rather that it has to put forward substantial and important reasons that would warrant or do merit the exercise of extraterritorial criminal jurisdiction. And finally, that as a result of this presumption is incompatible with a number of the doctrines that standardly regulate extraterritorial criminal jurisdiction under international law, including the doctrine of comity. The extraterritorial jurisdiction is just a matter of comity. No, I think it's a matter of right, and it's a matter of right that we don't exercise, states don't exercise extraterritorial criminal jurisdiction unless they have strong reasons. It's also an argument against extraterritorial criminal jurisdiction being just reasonable. We need more than reasonableness, and even it's an argument against subsidiarity. We need more than subsidiarity. We need a strong positive reason to exercise this kind of jurisdiction without affecting the rights of territorial states. Thank you very much.
Good morning, everyone, and thank you for being here for my presentation. So the paper that I'm presenting today is an early draft of one of the chapters of my PhD thesis, which is entitled Human Rights as Sources of Penalty. A longer version has recently been published with the Human Rights Quarterly. So first of all, I would like to spend a few words on two images. Oh, sorry. Well, sorry, I'm really sorry. So I was saying, first of all, I would like to spend a few words on two images. I searched on Google the words human rights victim and the word human rights perpetrator. So this is the picture, one of the pictures that I found when I searched human rights victim. And this is one of the images that I found when I searched human rights perpetrator. So the paper that I am going to present today explores how we have gone from the first image to the second one. How we have thought that to untie the first ends from ropes, we had to uncuff the second ones. At the core of my paper, there is a puzzle. Traditionally, human rights are considered as promises of freedom from state interference. Criminal law appears as the opposite. It is the body of law that interferes the most with the individual's private sphere. It expresses the highest legal censor of acts within society, and it provides for the harshest sanctions, including incarceration, and in some jurisdictions, even a loss of life. So generally, we tend to think of human rights as restraining state penal policy. Examples are the abolition of the death penalty, the protection of prisoners' rights, the prohibition of indefinite detention, and the criminalization of homosexuality. However, in recent years, human rights seem to have acquired also a different role. They have promoted the introduction of new criminal offenses, more policing powers, the institution of criminal proceeding, and harsher punishment. This has occurred not in a single country, but across and beyond the jurisdictions. So I tried to explore the historical developments of this phenomenon in my paper. The paper shows how since the late 1970s, domestic, regional, and international courts, policymakers, and civil society have come to rely on human rights instruments and language to promote criminal accountability around the globe. 5 different but interconnected trends are explored. The rise of victim rights language, the upsurge of penalty within the UN Human Rights Project, the criminal justice model within transitional justice, the promotion of human rights by international criminal law, and the penal policy of human rights bodies. I will now explore each of these trends. Since the 1970s, the phenomenon of victim rights in criminal proceedings has been at the heart of civil rights movement and policymaker concern, both at the national and at the international stage. The study of victims of crime adopted a more practical and policy-oriented perspective in the 1970s and the 1980s due to the combined effort of peculiar alliance, the women's human rights movement on the one hand and conservative law and order advocates on the other. This development first occurred in North America and later in the UK and later on in various other countries as well as internationally. This focus contributed to the rise of the victims' rights movement, which, since the 1980s, has tried to improve victims' interaction with the criminal justice system. Today, this movement is not homogeneous, and while in some countries victim advocates have not explicitly promoted the punitive policies, in order they have at times expressed repressive impulses by conducting campaigns for harsher punishment or for more incapacitatory sentencing policies. Two areas of particular relevance are sexual offenses and hate crime legislation. Though not overlapping, human rights and victim rights and human rights have many points of contact. First, the category of crime victim may overlap and often overlaps with the category of human rights victim. Second, the victims' rights movement has developed in parallel with the emergence of the human rights movement, and in several circumstances, the two groups have coincided, such as in the case of the battered women's movement and the anti-trafficking in human beings campaigns. The proposals of victims' organization have mainly focused on reinforcing victims' position in criminal proceedings. However, we should consider this trajectory was not inevitable. At the time, the movement could question the ability of the criminal law in protecting victim needs while focusing on alternative, non-criminal responses to victimization. Rather, despite the criticism of criminal justice institutions for being blind in respect of those affected by crime, victim support organizations designated the criminal law and its sanction as the primary response to victim suffering. More victim rights do not automatically mean more punitiveness, but their indirect influence, both conceptual and rhetorical, can play a part and eventually result in expanded penalty. Victim-driven criminalization has ultimately resulted in the inclusion of new offenses, stalking, sexual harassment, new forms of child abuse, hate crimes, Holocaust denial, and human trafficking, the expansion of the scope of some existing crimes, for example, rape, and the compression of traditional defenses, such as self-defense or provocation. A second trend is the emergence of UN instruments focusing on human rights enforcement by means of criminal law measures. Around the same time as the rise of victim rights at the national level, at the international, at the global stage, the UN has been a key actor in promoting human rights and legitimizing their enforcement through criminal law. It was the Convention Against Torture in 1984 that marked this turn to criminal law in the UN Human Rights Project. This convention is one of the first universal human rights treaties to set forth a duty for states to provide for effective criminal repression of serious wrongdoings by universal jurisdiction. Articles 5 to 7 of the Convention lay down the legal principle of aut dedere, aut judicare, whose purpose is to ensure that no safe haven from criminal prosecution is granted to perpetrators of torture. This principle had previously been deployed almost exclusively outside the human rights framework. The Swedish government, which proposed it, used as a model the corresponding provisions in a number of treaties against various forms of terrorism. As we can see from the image in the slide, the several examples following the Torture Convention reflect an increasing concern on the part of the United Nations to make prosecution and punishment of gross human rights violation legally obligatory. The use of human rights in encouraging increased penalty is also visible in the developments of transitional justice. By its very definition, transitional justice is concerned with accountability for human rights abuses of the past. Among many forms of accountability, criminal prosecution frequently figures as the preferred choice. Transitional justice is a field of scholarship, policy, and practice that began to emerge in the late 1980s. It is the result of a debate among human rights activists on how to deal with past violence in countries where democratic governments supplanted long-rooted dictatorships, in particular Argentina. Transitional justice presents a move from naming and shaming towards criminal accountability among human rights activists. Until the mid-1980s, human rights organizations had rarely called for criminal accountability. With the end of the Cold War and the collapse of oppressive regimes in Latin America, Africa, Asia, and East Europe, a new attitude toward criminal law emerged as no longer a source of abuses, but as a way to remedy them. Once accountability for past wrongdoings became possible, human rights organizations did not hesitate to choose as a model a criminal legal system already in place for ordinary crimes that were used in the past to prosecute human rights activists. The recourse to criminal law was not debated, but perceived as the obvious avenue for human rights enforcement. In early 1990s, the discussion revolved around the tension between demands of justice and the needs of sustainable peace. And a prominent example is the South African Truth and Reconciliation Commission, whose purpose was, amongst others, to extinguish criminal and civil liability for those who disclosed their wrongdoings during the apartheid period. However, over time, most human rights NGOs, courts, and scholars came to dismiss the tension between peace and justice, and criminal justice started being seen as complementary, no longer in opposition to peace. The turn of the century marked what has been called the justice cascade, or the revolution in accountability. Two events in 1998 have been described as the trigger moments: the establishment of the International Criminal Court and the arrest of Chilean general and dictator Augusto Pinochet in London on a Spanish extradition warrant for torture and other human rights violations. The Pinochet case gave practical effect to the Torture Convention and revitalized the principle of universal jurisdiction. The language of human rights is crucial in the enduring relevance of criminal law mechanism in transitional justice projects. Human rights are generally framed as legal standards that prioritize retributive notion of justice over political calls for forgiveness and reconciliation. Conversely, the absence of punitive measures is often regarded as a failure to uphold legal obligations, which in turn paves the way to further violence. The history of international criminal law is often narrated as a triumphant story of human rights protection. However, international criminal law has not always been concerned with human rights. The Nuremberg trials were primarily focused on aggression, while the Holocaust and other atrocities remained more marginal. It was only in the 1990s that international criminal adjudication was reinvented as part of the Human Rights Project and shifted its attention to accountability to human rights violations. The first international criminal tribunals after the Cold War, the International Criminal Tribunal for the former Yugoslavia and the International Criminal Tribunal for Rwanda, were not created initially for breaches of human rights law, but for war crimes. Yet, albeit primarily violations of the Geneva Conventions, the mass atrocities committed in the Balkans and Central East Africa were also read in terms of human rights violations due to their universal moral repugnance. Human rights law started being applied in armed conflict, and war crime trials became a new means to promote human rights. The institutionalizations of ad hoc tribunals have interest in creating a permanent international criminal court. The International Criminal Court, the ICC, was eventually established in 1998. Initially, widespread enthusiasm surrounding the ICC's creation obfuscated the limits of international criminal process in delivering justice for mass atrocities. In the last decade, however, this enchantment has substituted the initial euphoria. Great expectations of justice have been left unfulfilled by reality. Yet, the common explanation for what is usually called the crisis of international criminal justice is either generally the lack of state support of deficiency in effectiveness. The aspiration of international criminal justice have reportedly been frustrated because there is not good enough international criminal law. In other words, the general commitment to international criminal justice stands still firm because it is said certain things are simply wrong and ought to be punished. In this context, the connection between human rights and international criminal law is rarely contested. Academics, practitioners, and NGOs overwhelmingly agree that human rights are sources and the raison d'être of international criminal justice. Human rights provide normative legitimacy to the international criminal law, but also parts of its sociological and political legitimacy. Notably, victims and the human rights entitlement to criminal justice are one of the main justifying figures of the work of international tribunals. During the last 3 decades, human rights bodies such as the Inter-American Court of Human Rights, the European Court of Human Rights, the UN Human Rights Committee, and other human rights bodies have interpreted their mandate in monitoring compliance with international convention as comprising the imposition of obligations to criminalize, prosecute, and punish human rights violations. These institutions increasingly rely upon human rights law to order states to ensure criminal accountability at domestic level. The recourse to human rights instruments for enhancing criminal accountability is rooted in the doctrine of positive obligations and the theory of horizontal applicability of human rights. From the jurisprudence of human rights bodies, criminal accountability appears as an indispensable and necessary element of human rights protection. For human rights bodies, criminal law safeguards society as a whole by ending impunity and providing general human rights protection. All human rights bodies have also a tendency to require criminal accountability in the interest of individual victims. Since the decision in Panigua Morales v. Guatemala in 1998, the Inter-American Court of Human Rights has had no hesitation in considering criminal justice as an instrument to protect the rights of the victims and to give them restoration. For this court, but also the European Court of Human Rights, prosecution and punishment ensure retrospective restoration of the element of victim rights to have the perpetrator properly tried and punished. The case law on positive obligation in criminal matters has had considerable impact on domestic legal system. Pursuant to human rights bodies' decisions, states have started new criminal investigations, overturned amnesties, introduced new offenses, and created new institutions to facilitate the prosecution. So my paper has illustrated how the universality of human rights has enabled the criminal justice projects to spread and expand over time and space, mixing domestic and international elements. Human rights have helped criminal law to overcome traditional jurisdictional boundaries, from a criminal law strictly connected to statehood and sovereignty to criminal law unbounded as a global enterprise. Victim rights advocates, NGOs, practitioners, academics, judges, and policymakers have been involved in this process. But the expansion of penalty by reference to human rights have been welcomed without a serious debate. It has been normalized. We have become accustomed to requiring penal action for human rights abuses without interrogating what is involved in the relationship between two bodies of law, as human rights and criminal law, that are at once very different but entangled. As this occurred because criminal justice is necessary to provide human rights protection, or because discourses of criminal accountability have co-opted human rights, or perhaps it is because human rights and penalty are two sides of the same coin, each mutually dependent on the other. So these are some of the questions that I'm investigating in the rest of my PhD thesis, which tries to question the taker-for-granted relationship between human rights and criminal law, and to expose the assumptions that lie behind it and the interest it supports. Thank you.